The chair, for what purpose is the
I have an amendment at the desk.
Mr. Chairman, I have a reserve a point of order.
The clerk will report the amendment. Yeah, the point of order, the reserve is clerk will report.
Just to be clear, Ms. Schakowsky, is it February 10th, 2011, 1 p.m.?
Yes.
Okay. Amendment to the amendment in the nature of a substitute offered by Ms. Schakowsky.
Without objection, the amendment will be considered as read. Gentlelady is recognized for 5 minutes in support of her amendment.
Thank you, Mr. Chairman. Over and over again, what we've heard is the purpose of this bill is to address only the issue of abortion, make sure that there's no federal funding for abortion, and my amendment actually does the simple thing to clarify that this legislation only affects abortion. It reinstates the words regarding abortion that are contained in current law, and it adds the phrase regarding abortion to the vague and undefined term conscience rights. It's obvious that the Pitt's language, whether intentionally or not, is ambiguous about the reach of these so-called conscience rights, and my amendment would make clear that these provisions are solely about abortion. The conscience law in my own home state of Illinois is broadly interpreted. Let me share with you some of the provisions that make the law so broad. It applies not only to the refusal to perform any procedure to which a medical professional objects, but it also applies to counseling and referrals. So not only can a provider refuse to perform a procedure, that provider can refuse to provide counseling about it or to refer to another willing provider. It applies to a very wide range of healthcare professionals, institutions, and insurance companies. It applies not only teachings of established religions, but moral convictions, which can mean practically anything, because that is up to the personal interpretation of the individual or entity that is protected under the Act. The reason I'm concerned about the ambiguous reach of conscience rights in this bill is because some medical providers in Illinois have relied on the Conscience Act to do the following things. We first refuse to provide insurance payment for not only abortion, but also contraception. Refuse to dispense medications at pharmacies, and refuse to refer or transfer prescriptions to another pharmacy. This has included incidents where the pharmacist has assumed the reason the medication has been prescribed, even though he or she has not been privy to that information. Allows the pharmacist to make assumptions. Refuse to provide information or referrals for condoms for patients concerned about protecting themselves from HIV. And so this is an amendment that I believe clarifies the intention as stated by the majority of this legislation, and I would urge its adoption.
Chair, thanks, lady, and recognize the
Speaking of
Illinois, Mr. Schakowsky.
Thank you, Mr. Chairman. This was, in essence, part of the discussion that we had previously. The state of Illinois actually wants the broad protection of Illinois law. The state of Illinois is a very broad and tremendously diverse state, from south of I-80, very conservative-minded like myself, and in the great city of Chicago and Cook County, other great diversities of opinion. I think for the state of Illinois to have passed legislation is on a difficult issue such as the debate we have today is telling us that they've got it right for the state of Illinois. Our opposition to this is having the federal government come in and then dictate to the states what they can and cannot do under state law. And as we talked about earlier, there are issues, and it raises a debate, but I think the state got it right, and I would ask the rejection of this amendment to protect especially the state of Illinois and our broad protections.
Will the gentleman yield?
I would be honored to yield.
Thank you. I think that it's important then to underscore that the intention of this legislation is much broader than has been over and over again stated, which is simply to make sure that no federal funds go into go toward abortion. That clearly it's going to go into the realm of contraception, of prescription drugs, of condoms, and I would argue that that is far beyond the scope as originally stated, and far beyond the scope that it should go to. Thank you for yielding. I yield back.
I'm honored to yield. I would just follow and say that, abortion proponents have often blurred the lines between contraception and abortion, and they likely seek to overturn any state protections for pharmacists. This is really a pharmacy issue in the state of Illinois on what they can prescribe and what they can't, and those pharmacists who have strongly held pro-life views do not want to prescribe abortifacients. And they do not want to be forced under law to do so. That's why the law was adopted, and my colleague, Ms. Schakowsky, knows I have great respect for her. It's a great diversity of this country that we can have this debate, and I just disagree on this opinion. I yield back my time.
Sure. Thanks, gentlemen. Mr. Guthrie?
Thank you, Mr. Chairman. I withdraw my point of order.
Is there further discussion on the amendment? If not, the vote occurs on the amendment.
I would ask for a roll call vote.
All those in favor shall signify by saying aye. Those opposed, no. The clerk will call the roll.
Mr. Burgess? Mr. Burgess, no. Mr. Whitfield? Mr. Shimkus? Mr. Shimkus, no. Mr. Rogers? Mr. Rogers, no. Mrs. Myrick? Mrs. Myrick, no. Mr. Murphy? Mr. Murphy, no. Mrs. Blackburn? Mr. Gingrey? Mr. Gingrey, no. Mr. Latta? Mr. Latta, no. Mrs. McMorris Rogers? Mr. Lance? Mr. Lance, no. Mr. Cassidy? Mr. Cassidy, no. Mr. Guthrie? Mr. Guthrie, no. Mr. Barton? Mr. Barton, no. Mr. Upton? Mr. Upton, no. Mr. Pallone? Mr. Pallone, aye. Mr. Dingle? Mr. Dingle, aye. Mr. Towns? Mr. Towns, aye. Mr. Engel? Mr. Engel, aye. Mrs. Capps? Mrs. Capps, aye. Ms. Schakowsky? Ms. Schakowsky, aye. Mr. Gonzalez? Ms. Baldwin? Ms. Baldwin, aye. Mr. Ross? Mr. Ross, no. Mr. Weiner? Mr. Weiner, aye. Mr. Waxman? Mr. Waxman, aye. Mr. Whitfield? Mr. Whitfield, no. Mr. Pitts? Mr. Pitts, no.
The clerk will report the result.
Mr. Chairman, 9 aye, 15 nay.
The amendment is not agreed to. Are there any other amendments?
Mr. Chairman.
But for what purposes? Gentlemen, seek recognition.
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Mr. Chairman, I reserve a point of order.
Gentleman reserves.
Amendment to the amendment in the nature of a substitute offered by Mr. Pallone.
Without objection, the reading of the amendment will be dispensed with and the chair recognizes the gentleman from New Jersey, Mr. Pallone, for 5 minutes to speak in favor of this amendment.
Thank you, Mr. Chairman. My amendment would strike the Pitts language that applies the refusal protections to the application of emergency services laws. While the Republicans have argued that the Pitts bill protects hospitals, medical workers, and health clinics, in my opinion, it actually overturns decades of precedent that guarantees public access to emergency care, including abortions. The EMTALA statute prohibits hospitals from dumping a patient who is medically unstable. If a patient arrives in a life-threatening situation, the hospital must treat them until the person's life is no longer in danger. The health care reform made clear that the conscience protections that were written into the law did not repeal or amend the basic EMTALA provisions requiring hospitals to treat a patient until she's stable. And now the Pitts legislation, in my opinion, changes that. It says that EMTALA is subject to the abortion provisions. What does that mean? It means that if a pregnant woman's life is in danger and the medically indicated response is to terminate the pregnancy to save her life, that the hospital can refuse her emergency care. It could also refuse to transfer her to another facility saving procedure. Now, I know that when I asked counsel at the beginning when we were discussing the substitute, I got an answer from the chairman to my question. I thought that the chairman said in his response to my question earlier that he agreed that that is in fact the impact, that if a pregnant woman's life is in danger and she had to terminate the pregnancy to save her life, that the hospital could refuse the emergency care or refuse to transfer her to another facility. That's how I interpret what the chairman said in response. And for that reason, I think that we need to make sure that that language is stricken and that and therefore support this amendment. I would yield back the balance of my time.
Chair, thanks, gentlemen. Recognize the gentleman from Texas, Dr. Burgess, for 5 minutes.
Thank you, Mr. Chairman. Actually, might I just ask a question of counsel? Does the Pitts language as written, unamended, does it change EMTALA in any way?
It does not amend EMTALA in any way.
And I thank counsel for that observation. I would just point out Title 42 of the U.S. Code, where EMTALA, an emergency medical condition, is defined. It's fairly clear. An emergency medical condition means, amongst other things, one of the stipulations is placing the health of the individual or, with respect to a pregnant woman, the health of the woman or her unborn child in serious jeopardy. There are other provisions that do address the issue of transfer. With respect to a pregnant woman who is having contractions, number one, that there is not adequate time to effect a safe transfer to another hospital before delivery, or two, that the transfer may pose a threat to the health and safety of the woman or her unborn child. Earlier in the code, transfer is also addressed. An appropriate transfer to a medical facility is a transfer that minimizes the risk to the individual's health, and in the case of the woman in labor, the health of the unborn child. So I think the statute under EMTALA is fairly clear. I think the amendment, therefore, is not necessary. As the counsel has indicated, EMTALA is not amended under the Pitts language in the amendment in the nature of a substitute, and for that reason, this amendment is not necessary. The language that exists in EMTALA today, the law under which every practicing physician understands that within 30 minutes you must provide evaluation, stabilization, or transfer. That does not change under the existing under the language that's offered in the Pitts Amendment in the nature of a substitute. With respect to the term stabilize, with respect to emergency medical conditions, that no material deterioration of the condition is likely within a reasonable medical probability to result from or occur during the transfer of the individual from the facility. I mean, the law is fairly clear. It's very clear. And certainly there was no ambiguity in my mind back in the days when I was responding to emergency calls from the hospital that I had a certain time limit in which I must respond to the situation, treat it if I was able, stabilize and transfer if it was beyond my capability. And nothing in this language is going to change that. So the amendment, in my opinion, is not necessary.
Can I ask the gentleman to yield?
I'll be happy to yield to my friend from New Jersey.
What I don't quite understand is, I mean, it seems to be what you're saying is very different from what the chairman said before. If there was no change, then why do we have to have the Pitts language? Because this wasn't in the original Pitts bill that was introduced. It was added. It was put into the substitute. It seems to me that what you're doing is basically subjecting EMTALA to this refusal language. And my understanding in response to my question, that Mr. Pitts said that is what he intended. if you think that there's no intention in that regard, then there's no reason not to vote for my amendment.
Well, reclaiming my time, it is for the reinforcement of the longstanding conscience clause. And I'll just tell you as a practical matter, if a situation occurs where delivery is imminent, no, you cannot transfer that patient, but that's no longer an elective termination of pregnancy. That's treatment of a medical condition.
Well, would the gentleman yield again? If I could ask unanimous consent to enter into the record a letter from the Catholic Health Association of the United States.
If the gentleman would allow me to see the letter before.
Sure. And I mean, it basically says that he didn't think it was necessary to have the Pitt's language.
I'll yield back my time.
Gentleman yields back. Is there any further discussion?
Mr. Chairman, there was no rejection?
No.
Oh, I see.
Okay, I mean the letter.
Mr. Chairman, I have no objection to the insertion of a letter for the Catholic Health Association, but I would ask unanimous consent to insert a letter from the Catholic Medical Association alongside.
Without objection, so ordered.
Have I seen that? I have no objection to that either.
Is there further discussion? Gentlelady, Ms. Capps, recognized for 5 minutes.
I won't take 5 minutes, but I do want to speak in strong support of Mr. Pallone's amendment because I think the underlying legislation is unclear and that this is a very important regulation that we have, EMTALA. It saves countless lives every year. And just to affirm, I believe if there is disagreement on the other side that there needs to be this amendment, I think we need the amendment simply for the purpose of clarification. It only ensures something that is stated law now and is in practice, that hospitals and medical providers which receive federal dollars are required to provide emergency service and treatment regardless of one's ability to pay, but also regardless of the kind of procedure it is. Under this extreme legislation, the underlying legislation, hospitals would be allowed, at least it's vague enough that it could be interpreted that hospitals be allowed to turn away women in need of services, including termination of pregnancy, even if the life of the woman was in danger, and that even referring such patients could be denied because of the Conscience Clause provision. EMTALA was put into effect to save lives, specifically saving the lives of pregnant women, and I believe that this amendment is important to underscore that fact and make sure that this legislation, this bill that we're considering, be in conformity with the rules of EMTALA, and I'm prepared to yield to the amendment's author, Mr. Plum.
Thank you. You know, one of the concerns I had during the hearing on Wednesday, the hearing was so quickly followed up by the markup that unfortunately we haven't had a lot of time to sort of digest some of the statements that were made. But I continue to point out that there are circumstances where it may be necessary to save the life of the mother, that the pregnancy is terminated. And many times those who were, the anti-choice advocates said, well, that's never happens. But it does happen. I mean, we had a situation which got a lot of attention in Phoenix where there was a situation where the hospital, which was a Catholic hospital, made a decision that they would allow abortion or ending the pregnancy because of the mother's life. And as a consequence, the bishop stripped the hospital of its Catholic status and excommunicated the administrator. So these situations do happen. And it seems to me, as Ms. Capps said, that if there's some question on the other side of the aisle as to what they're really trying to do here, then there's no, and the Catholic Hospital Association has said, there's no need for this Pitt's language. So just to make sure that we don't have these circumstances occur where, a woman's life is in danger and somehow she could die if the wrong decision was made, it seems to me that you should support this amendment. And I yield back to the gentlewoman.
Yes, I just wanted to put on the record some of the words from the Catholic Health Association of the United States regarding this issue. And it says, we've had the opportunity to review your revised version of H.R. 358 and would like to share our concern regarding one specific modification to your legislation. CHA, Catholic Hospital Association member hospitals, have been providing compassionate, quality care under both EMTALA and the Weldon Amendment without conflict since the enactment of these provisions. Accordingly, CHA does not believe that there is a need for provider non-discrimination section to apply to EMTALA. So I have to say I'm very confused unless there is something that we don't understand about the Pitts Amendment, about the Pitts language, why it is that we would have to extend to that we'd have to have that language at all, since it's a national leadership organization of more than 2,000 Catholic healthcare systems, hospitals, long-term care facilities, sponsors, and related organizations. And so I think that their word on this particular issue and their general support, by the way, they would like to express our continued support for the intent of your legislation, H.R. 358, but they are objecting to this particular part of it, and that's why I think we should not include it in the final legislation.
Young lady who has the time.
Yes, I yield.
I'd just like to ask Mr.